you.
Oh, sorry, we're recording now, so everybody on the call is aware.
Good morning. Thank you. Sorry for the small delay. Let's get started with the mission statement. The mission of Nevada State Board of Cosmetology is to protect the public health, safety, and welfare of those that obtain cosmetology-related services through the delivery of quality testing, licenses, inspection, and education services that focus on consumer protection.
Kai, 1 second.
Yes.
We'll go back to roll call and then we can continue on with the rest of the meeting.
Oh, I apologize. I thought it was already in, I'm sorry. Go ahead.
Nope. Okay, so you can call for roll for the members and then call for roll for anyone from staff.
Let's start with staff, please, for roll call. Thank you.
Gary Landry, Executive Director.
Leah Easter, Chief Compliance Officer.
Maggie Adams, Compliance Specialist.
Lauren Gossage, Regulatory Compliance Specialist.
I think that's it for us.
Thank you. And let's start off with the board, please.
Good morning, Board Member Harris. Here.
Good morning. This is Matt Brenton, Subcommittee member.
Good morning, Brian Baltazar present.
Good morning, Board Member McCormick present.
I think that's all of the board as well.
Perfect. Thank you. Is it okay if I'm sorry, go ahead.
You can go ahead. You've already done the mission statement, so you can go down to C, comments from the general public.
Yes, thank you. May I please have comments from the general public, if any? Please keep them to 3 minutes or less if possible. If we don't have any at this time, I would like to move forward to section D for the subcommittee law review. Looking at number 1, we look down for, I'm gonna blow that up just a little bit, NRS 644A 505, duplicate license or certificate of registration of fee. This is just reviewing, if you're looking at section 1, a person licensed or registered due to this chapter may obtain a duplicate of that license or certificate. To obtain a duplicate license or certificate, a person must request a duplicate license or certificate from the board and pay a fee of $25. I think that stands as fine. If there's any one that has any suggestions or think that there needs to be a revision to this, now is a good time to open that up. I would like to open up to the floor before I open it up for board to discuss. If there's no one at this time that looks for any extra revision, is there any board members that would like to? At this time, I would like to consider this to stand. May I please have a motion? Am I going in the right direction? I'm sorry, Gary, am I going in the right direction to ask for a motion?
Yes, you are. Just ask for motion that you want to keep the language the same and not change anything. And that'll be reported to the board at the next, not the next board meeting, but the board meeting in January.
Okay, thank you for clarification. May I please have a motion to allow the verbiage and the law to stand as is?
Brian Baltazar, I motion.
Board Member Harris, I second that motion.
Anyone would like to deny that motion or would like to have all the names? Anyone?
Board Member Stanton, it seems like you might be breaking up a little bit. I think you called anybody in opposition to that motion. Is that correct?
Yes, I am. We have bad reception over here. I apologize.
Reno's a hard place right now. It's okay.
Yeah. But can you hear that I called for anyone opposed
Yeah.
Can anyone hear me on that? Okay.
Yep.
So motion carries. Is that correct? Can anyone hear me?
Yep, you're fine. You're good for number 2.
Thank you. Discussing NRS 644A.530. This one's referring to display of license or certificate of registration. The holder of a license or certificate of registration issued by the board to practice any branch of cosmetology.
Board Member Stanton, I think we've lost you again.
Can you hear me now?
We hear you now.
Yes.
Okay, sorry about that. I was reading section 2. Did everyone hear me in section 1?
Sure. Yep, you're good for 2.
Okay. If a person practices cosmetology in more than one place, the person shall display the license or certificate or duplicate of that license or certificate wherever he or she is actually working. I would like to see on there that it's required to have a duplicate. I don't know how any other, or I would like to leave that comment on the floor for board members to discuss, or just to leave it as is, as well as public. I would like to open it up to the board discusses this. If this verbiage is okay, or that needs to be had for this section.
I do have a note on this before the subcommittee discusses. One of the things that was brought up about this provision by the board quite a few meetings back was whether this law should be clarified that the license needs to be posted where someone is actively and presently working. One of the issues that the board members will remember came up is a lot of salons will post the licenses in a central location, maybe behind the front desk, and then the inspector will go in. It becomes more difficult to determine who is which license, especially with masks. A lot of nail salons will wear masks. Obviously with COVID, everyone is wearing a mask. So I believe that's why you had pulled this NRS initially. I just wanted to throw that out there as part of your discussion.
Okay, so there was conversation regarding, and we're talking about like the LLCs as far as our major corporations, meaning their station is switched out. There's no particular place. It's kind of like first come, first serve because they're on an hourly rate. And then I do remember something similar.
That's a good question. Yeah, because every salon, so that the NRS obviously would apply whether you're a big corporation or a mom and pop shop. And so we would just be determining where your personal license would need to become. The board said as it was written, the feeling was that a central location was fine, but there was discussion that it made sense that it would need to be at your active workstation, whether you're a big place like the Qua Spa, for example, or you're a mom and pop shop, down on, Main Street. And part of that reason was, again, because it's really hard to tell which licensee belongs where. And we got some feedback that, well, I might move my station and I work in different stations. And so we were just discussing, well, should that license move with you or should it be hung in a central location, that sort of thing. So I guess that's still kind of up for discussion.
That's a
And I'm not sure if you're speaking, board member Stanton, but we're not getting.
Can you hear me now? Is that better?
Yeah, that's better.
Okay, my concern is if an inspector walks in, and we do want them safe, is 110%. It's a little challenging trying to chase down if that person is not there and there is no license there, and the station or something is a disaster that needs to be addressed accordingly. Who do you address that to? And it would have to be the owner, especially if the inspector, we're kind of sending them on a goose chase hunt by not giving them the current information on what they need to do their job accordingly. So I would have, yeah. Okay.
And in addition to that too, obviously us being a consumer protection agency, you want your consumer to sit down and say, this is Kai Stanton, she's a licensed cosmetologist, I see her C number here. If something happens, I know who to call or who to ask for. That sort of becomes more challenging, right? If you're not sure who's performing your service, you're probably not going to go to the main desk and try to guess who that person was. So again, just something to think about.
No, and people are becoming, intensively protective about their environment and coworkers, as they should accordingly, but I don't want inspectors in danger either, dealing with a aggressive, trying to find out X, Y, and Z also. So I would like to leave that open to the floor because here's my solution. You need to have it at your station. You need to have a duplicate if you work in more than one area or that is not your station. Accordingly, you need to take that with you or place that at the front desk. And then as you're working, place it at your station. There is a common hook that you can put on that needs to change out your license, especially if you are not designated for that area. I know one of the salons that does that, and it's kind of like first come, first serve, or it depends on who was on that shift, etc. So no one ever has the same station. So it's kind of hard to find that person. So it would end up going to the salon directly, which is, it's overwhelming. So I am going to leave that to the floor because I'm not sure how that really works because I'm not in there. I can only say on the outside looking in, there's some challenges there all the way around with just not having the state. I think that should be a requirement to have duplicates. What can I leave that open to the floor, please, to discuss and see what type of solutions that maybe the board can come up to the Nevada State of Cosmetology Board. Is there anyone that has a view on this at all with a solution that may be a better direction for the public?
Hi, Kai Stanton. This is Gwen Bramo. Hello, everybody on the call.
Hi, Gwen.
Good morning.
Hey, can you repeat that one more time? Because I'm getting ready to pull it up. I'm just on my iPad and my computer. I'm still here at work though. So can you repeat the question again?
So my question to the floor is, to the public is, as well as board, what would be a great solution for this? Because my number one concern is fines will go to the owner. I mean, if the inspector cannot find who is working at that station and there's several different people that are utilizing that space, it is overwhelmingly and can potentially put a risk for our inspectors to avidly try to hunt down someone when, not everyone is so forthcoming, chasing people down, etc. I would like to eliminate that stress. I would also like to licensee to be more accountable for the space, whether they're hourly or not. And so I believe they should have duplicate license or only posted at their station as they're working. So,
okay, can I just make a comment? And this is a comment and it's a concern.
Okay.
I feel personally that the only way that we as a state board is going to be able to hold the licensees accountable is to be able to, if there's multiple people working at a station or one person working at a station when then the inspector goes there, if that person is not there, that license need to be posted. What I do feel that is unfair to the actual owners, because there's a lot of owners that don't work actually in their business. And I know that they should be responsible or have a manager or somebody responsible for the business. But when our state is unique, a little bit different than it is in a lot of states that there's a lot of states that still just do strictly commission, where the manager actually oversee, they work for the company. But in Nevada, we're unique. We're more like a lease space booth rental type of environment. At what point do the operator or the licensee take accountability for their own actions, not just their actions, but the health and safety and sanitation of their clients? So if a license is posted at your station, whether you are there or not, when our inspectors walk in there, we know exactly whose station that is. If more than one person utilizes that station, then the person that utilized that station last still should have a license there. We're gonna have to try to figure out a way, or we're not gonna be able to man it. We're not gonna be able to continue. I mean, how many times are you gonna find the salon owner, because there's a licensee that works there that is not practicing safety sanitation? I mean, I'm being totally honest. It's not gonna work out good in our favor. The person that's actually servicing the client should be the one that's responsible for the citation, not just the citation, but practicing the safety and the sanitation. They're the ones that servicing the client. So how do you do that unless we put something in law where a license need to be posted at the station actively where that particular person is working? If the licenses are up front, how do I know if the person's license is even valid? How do I know if the license is not expired? I've been in some places where I had to look on the wall and I've seen expired license. It's like, okay, how did the license be expired for 8 or 9 months and they still practicing? You just can't man it all. So, I go back to the place, the person is no longer there. But I mean, what do we do as a board? I mean, we can't really babysit. The person that's sitting at that station needs to be responsible, period. That's my opinion.
And I thank you so much. I totally understand what you're saying. I guess my concern would be two. Are they hourly or are they, because then that makes them an employer. So if they are being employed, if they're an employee, right, and you have an employer, there would be two totally, if you will, almost like not separate rules, but the owner is resuming more responsibility if they're hourly and they're taking their license down and they're gone. I guess that I'm not sure. From the last cases, it sounds to me as if they are either sharing stations or what have you, or, the schedule or what have you, whatever the situation is, the stations is a disaster within someone's establishment. It's either if they are paying booth rent, that means they have a business license and that's their business space, it would go to them, right? Totally get it. It's posted, the business license, everything's posted, totally get it. But if you have someone utilizing the station and they're coming and going without a duplicate license, well then how, and that's the question, how are we willing that in without saying who's responsible, right? So if the employee is an hourly, she works from 9 to 3, and then someone from 3 to 6 comes in, right? So the 3 to 6 employee is now responsible for whatever the 9 to 3 employer didn't do prior to, which is all in-house, process, just like anything else. We don't go from the day-to-day in process. We're just looking at from the whole package altogether. Where is the accountability lie when no one is there? And so what does that law look like? What are we putting into place? The only thing I can think of is duplicate license to ensure that it's actually posted, or that would also be in-house to have a requirement. Rather you're working here, if you're the last one here, your license need to remain there until the next employer comes in or what have you. But understanding that anything happens within that station from this time frame to this time frame is your responsibility according to inspector and law. So I guess that's where it gets really sticky. If it's not posted, just like what you said, if it's not posted at your station and the station's a mess, and say I work next to someone that has a disaster of a station, but my station is immaculate. My license, everything is posted, but the person next to me, it's a disaster. What do we do? What does the inspector do? The fine has to go somewhere. And that's my question. Where would the fine go? Who would the fine go to? And we don't even know whose station that is. So we don't know to find them without having their license posted or what have you. Now we have to chase down the owner to say, hey, X, Y, and Z. Do you get what I'm saying? And sometimes they don't respond back. Sometimes the board is completely ignored, staff is trying to chase down who was in that station. So I guess that's where my question is, for us to protect everyone across the board, what would be the suggestion for that solution to make sure the fines get to the right person so the owner isn't constantly fined? But then if you're holding the business license and we can't find that person, it's kind of like the friendly ghost gone. What do we do here? Because I don't really have a solution other than let's just give it to the owner and move forward, you know, because then we get into the whole we're investigation, you know, situation. It's just a lot of money wasted, a lot of resources. So and that's why I'm asking all of you to help me out with this, to have a better solution on this, because like I said, I'm trying to simplify it as best as possible. So if you have a solution, I'm quite sure the board as well as public will be more than happy to see that as well, or anyone else for that. But I do believe it has to be posted at their station, period. But let's just say we do make that a requirement. You have to post it at your station, period. So you go into, I'm an inspector, I go in, and nobody's in that station. Everybody else license is posted, but nobody's in the station, but the station's a disaster. How do we rectify that? Hello?
Well, if this is Gwen Bramo, if the license is posted, then the person receives the citation. So whether the person is there or not, there should be a license at the station. I mean, first of all, we have a law that states that the license have to be posted in public view.
Yes.
So if it's not in public view, I'm sitting at a station to get a service. I don't know if this person is licensed or not. I don't even know what the name of the person is unless they tell me their name, if I can't look and see their license. So I don't know if it's a valid license or not. So if you're gonna go from salon to salon or business to business, then why wouldn't you have a duplicate license? What happens if you're in a hurry and you forget your license?
So, and that's what I'm saying. Should we put that in law that you are required to have a duplicate license, but how would that still protect the salon owner?
Oh, this is Leah Easter. I think to maybe sum up what both of you are saying. So you can get a duplicate, anybody who's licensed, as many as you need, really. But in terms of protecting the salon owner, but more importantly, protecting the public so they know who's working on them, you know, outside looking in as the regulatory agency, it doesn't seem that difficult to me to move a piece of paper to my new workstation, even if I have 10 different stations. I don't know if you all feel differently, you're the professionals. But yeah, you could get a duplicate, or we could just, I think what everyone's saying is maybe we clean up the language of 644A 530 a bit to make more clear that when you are physically working, your license needs to be at that physical station. And you're right, we're probably gonna have still some issues where people take their license, we're left with the salon owner, but it would hopefully cut down. That way we're not dealing with licenses hanging at the front desk. They probably are gonna leave them at their workstation, and that might help the problem somewhat and help the consumer feel like they know who's giving them their service. And if you're good with that, that makes total sense. We can bring that to the full board and then later to the LCB. So.
And the change would only be under number 1, where it says in view of the public at the position, change position to workstation. I think that'll clarify a lot of the confusion that's going on, because position, they said, well, that can be at the front desk, can be here and there. No, at the workstation where the person is giving services. So if we change the word position to workstation, I think it's a good first step to getting this cleaned up.
And to your point, board member Stanton, you might have more than one workstation, which would mean a duplicate is probably in your best interest, and we can obviously accommodate that.
Yes, I like that. I just want to clarify, because I think I misunderstood something slightly, which changes kind of a little bit. So am I understanding, for example, walking into the salon, let's say there's 3 workers, but 2 are not physically in the building. There's 3 workers, but 2 are physically not in the building. And there is no license to be found, right? The owner would get the fine. But if 3 workers are working there and say all 3 are there and they do not have their license posted at their workstation, they have it posted at their desk, at the front desk for some reason, right? Because whatever the reason is. Are we saying that we're fining the owner for that and not the licensee holder for not posting it in public view? Because those are 2 different scenarios here, and that kind of changes things.
Yeah, I would say we would not fine the salon owner. We would fine the person whose license was not posted. They're responsible to make sure that the license is posted at their workstation.
Right.
If it's not posted at their workstation, they're going to get the fine. We'll have to find out what their name is, because like you said, it's not very apparent or evident who they are, but we'll get their name and then we'll write down their license number and fine them for not having their license at their workstation. And we don't have to do this, go in like we're going to fine everyone who doesn't have that. We can tell them you need to have your license at the workstation. It's not posted. Do that for a month or 2 while we're getting things cleaned up, and then start fining them, saying, we told you last time to move it. You still haven't. You're getting a fine now.
Okay.
And
I
this
like
is Matt
that.
Brenton, subcommittee member Matt Brenton. Just one practical implication to this when it comes to like a medical spa setting. I understand if it's a booth where you're performing barbering services or something, but oftentimes in these day spas or medical spas, an esthetician might have 5 or 6 rooms where he or she could rotate and be working throughout the day, depending on what service is being provided. So the way we're talking about this, they could potentially need to have 5 or 6 different licenses, all over the walls in these different rooms. So I just like that to be considered when we're talking about requiring a license to be hanging at every single workstation.
Thank you so much, Matt. I appreciate that information. My concern is if you're an inspector, right, and you go into a room and say you've had some multiple concerns, okay, and you go into a spa, maybe your license is posted around the corner in Studio 93 on the other side, but you're working in Studio 7 and the inspector comes in. How would the inspector know X, Y, and Z, or who to discuss with unless they directly speak with you? And sometimes they're not so forthcoming and giving you their information. It's a lot easier to look on the wall, see who it is, write it down. I noticed they had X, Y, and Z laying out or what have you and moving forward versus saying, excuse me, where's your license? Where are you at? Can I talk to you? Sometimes it can be a little bit overwhelming. So it's kind of a chance you're taking. Not everyone's studio is like right next door, which would be ideal. Absolutely. But looking at the overall view of the state, not everyone has that luxury to work like that. So I don't think that the board is saying at all, if your rooms are right next to each other, you know what I'm saying? I don't think that's what they're saying. I think that's what they're saying is if they have no clue, you know what I'm saying? No, the studio was way far. It's clearly on the other side. We can't see anything, but if it's pretty in proximity of where you're working at, and you can say, oh, it's right here. You can pretty much point to it. I think the inspector is good with that. The past cases that we have seen have been like and large settings of mainly, like you said, booths, things of that nature. We've also had change out of rooms, meaning there's a tattoo artist in there and then now an aesthetics, and now they're doing, you know, whatever. In that particular room, it's constantly being changed out. So yes, you have to have your license posted continually every time you're doing in that particular room. So certain circumstances change a little bit. But I just want to clarify, if you're in suite 1 and suite 2, 3, 4 is right next door, and you're doing whatever facial service at that time, I don't believe inspectors would find someone because your license was in suite 1 and not 2. It's pretty visible to the public because it's right there. I hope that clarifies a little bit. Leah, can you follow up with that if that's accurate? Because Matt does have a very good point, and I'm quite sure other people will have that concern. So I just want to clarify, that's still in view of the public. If we're talking like one step over, that's still view of the public. We're not talking about on the way other side of the building, correct?
Right. Like, and Matt brings up a great point, and Maggie, who's here, you know, worked in the massage industry for years. And one of the things that, you know, she had thrown out too is you might work in 25 different rooms all day, but maybe your license is in a frame, maybe it's laminated, maybe you, as you're bringing over your towels, your clean shears, etc., you just set up your license. So you're not even buying a duplicate, you're just moving the one you have. And again, I mean, inspectors aside, fines aside, it's a consumer protection thing as far as the board views it, because, you know, if I'm in a room with someone and something, you know, happens, God forbid, who am I in the room with? Who am I going to ask? To your point, not everybody is forthcoming. Is this person a licensee? Is this person, you know, and we do have to sometimes hunt people down. And I know the board has heard a few cases like that. You know, it's kind of like who's on third. Everybody's giving you a different name, and you end up, you know, with the runaround. So yeah, no, everything you said is true. Matt's points are valid as well. I think it's just about coming up with, you know, a middle ground that protects the consumer and is reasonable to the licensees.
Does that help, Matt, a little bit as far as clarification on inspection and how the verbiage will be? We're not changing the whole alteration of, just slightly, so that there's clear clarification, which protects both parties.
Yes, well said. I think if the language were modified to say in plain view of the public at the workstation, that might be specific enough language to necessitate a patchwork of licenses in every room, or requiring, you know, practitioners to haul their license around to different locations, which, you know, I would be opposed to. And I think all medical spa, day spa, massage, you know, kind of would be opposed to, versus a, you know, a barber that's practicing at one particular workstation. And I do understand the concerns. If it's difficult to identify who's performing the procedure, if it's not there hanging. But I think every profession deals with that, whether it's a physician or a nurse or attorney. I mean, they don't haul their licenses around to every room that they meet with a client in. And I think as long as it's in plain view of the public, that's the operative language. For example, in our spas, they all hang, the licenses hang prominently in the reception area at the front desk, where it'd be easy to point to the individual who performed the procedure if it was needed, or an inspector could easily come in and see that all the licenses were up to date in one location, versus having to go into room by room. I'm all for language that allows for the operative language, plain view of the public, to be highlighted without the unduly burdensome requirement to haul licenses around and have every room, you know, have this patchwork of licenses on the wall. And I think the purpose of the law can be met, which is to give the public, to give inspectors the ability to see, okay, who's here working? Are these licenses up to date, without being unduly burdensome?
Thank you, Matt. And I think that your point was very valid as far as the view of the public. I think if we say workstation, you're kind of painting yourself in a corner again with duplicates or carrying around and all the other fun stuff. The challenge with that is that we have to look at it from all spectrums and from all areas of all industries. And with barbers, they travel. You know, a lot of people travel, Cosmos travel. So taking a look at all aspects, aesthetics, as well as barbering, not really barbering, because they have their whole board within themselves. We don't even govern barbers at all. But as far as cosmetologists, nail techs, aesthetics, things of that nature, looking at it in a full view, and we have to make statements to cover all areas. That's why we said view of the public. As far as the workstations go, there has been multiple challenges posting it at the front desk. We've already seen the outcome of that, unfortunately, and how well that is not working out. And so now it's time for us to create a solution that best fits. And I think Leah was able to determine that in just a small additive, excuse me, to the law by allowing what you just said, not having to transfer it, you know, from room to room to room or multiple duplicates. It's in plain view of the public within X, Y, and Z. And maybe we need to add that in within 3 feet of your workstation or within 10 yards of your workstation or what have you. Just as long as it's in plain view, it's easy for the inspector to read. And that's what we need to do to make sure that it's easily, recognized what's going on. And I think we're all saying the same thing. We're just trying to make sure it's executed appropriately and abroad to make sure it fits everyone accordingly. So thank you for that. Is there anyone else?
Board Member Stanton, it looks like Euphoria has their hand raised.
Oh, yes, I'm sorry, go ahead.
Hi, I apologize for being a little tardy, but I just wanted to jump in too. You know, at the school, we have all of our licenses centrally located in one area. And I feel like, I agree with Matt, I think that if we just did that same concept in salons and spas, that would really allow the public to see and make sure that whoever their practitioner is actually licensed in plain view. And I think that, you know, as far as fines go, I kind of feel like there's a responsibility to the person that owns the salon. Now, if that person, you know, there's a lot of contracts that are being formulated for practitioners to sign to work in a salon. And I think that management of how that salon owner handles fines would be between her and her tenant. But at the end of the day, I think it's the responsibility of the salon owner. If there is something awry and if there is so many possibilities, there's so many people using one station, then the responsibility has to fall on the owner and the person that is renting that station to multiple people. You know, it's her responsibility to maintain a clean sanitary environment and to make sure that happens on all stations in all aspects. So that's just my opinion on the licensing duplication. I think the idea of a duplicate license is good if you have somebody that works in more than one salon.
Right.
That's a reasonable reason to have a duplicate. But I think that, you know, we've been doing it here at the school forever. We have a wall, everybody's got their license on it. And, you know, the inspector comes in and she makes sure that everybody who, you know, we say we have 20 people, that there's 20 licensed. She does her due diligence, you know, and if there's a fine, it goes to the school. And I think that works. And I think it should be, I think it should be applied to salons and spas as well. Thank you.
I just have one other comment. This is Gwen. And I agree, Lou, with you, but the only exception is that when you're in the school, and I agree, everybody normally keeps up the licenses on the walls for the inspectors to see. But when you're actually in employment, if the salon owner or wants to lease out a station, one particular station to 4 or 5 people, and they have an agreement, then the salon owner can go to those people and say, okay, it's 4 or 5 of you need to pay this fine or whatever, however they want to handle the situation. I totally agree. But for licensing and an inspection purposes, to making sure that it's safe for the public. I just wish that we as a committee could move forward with making sure that the license is posted at the individual station. So when the consumer comes to get the service, they'll know who's servicing them. They'll know who, if the person license is active, even if it's the same person's face on that license. I mean, even knowing the person's name, in case there is a complaint. I don't think we should just be chasing after, just walking in as inspectors. Said, okay, I can't find the person, I'm just gonna find the salon. Okay, that's fine. But what about the person that's gonna continue to not practice safety sanitation? Because that's what we teach in school. So my concern and my comment is that those that decide to be business owners, because that's what you are. You're a business owner when you're leasing a space. You need to take responsibility, post your license, and if you're fined, you pay your fine. In the school, we post our license because we have licensed educators educating our students, and we want to be able to show the public that we have licensed educators. I think I don't want to us to get on the thing where we're going to start confusing that. But if I've signed a contract to work at a particular place, then I need to be responsible with everything that comes and goes along with it, because you are an independent salon owner. You're just working up under a landlord. That's all my comment.
Thank you. I think I'm hearing almost three different arguments, actually. So one, I do understand what Matt is saying. He had a very good point regarding the setup. As long as it's in plain view and the studios are right next to each other for any particular service, that's in plain view. If you're in a school and you have all the licensing, because of course students don't have licenses, instructors do. So you can tell that they're an instructor, they're in an hourly. That's a totally different process as well. And then you have your hourly that, from a Smart Cuts or whatever these businesses are that hire you, and they change out and their licenses are at the front desk. And then you have those that booth rent, which is like a lease for your business, for that station. It needs to be at your station with the business license posted. So are we using this law across the board for all of these situations? And I see why everyone has a different stance. Is there a way? There really isn't. Honestly, and I do agree. I don't think we need to have so many multiple duplicates unless you're leaving. I don't like to say, it's pretty obvious, because some things aren't as obvious as we would like them to be. So how can we clarify this, Leah, so it's not confusing? Because honestly, everything that was stated today is facts, especially if we have a new inspector and say there is a new skincare studio X, Y, and Z. How do we know those inspectors are going to, it's in plain view, but they're in room 3, but it's in front of room 1. Like, are we making sure across the board that the verbiage and the situations are clarified? So and I know that leaves a lot of responsibility, but it's almost like we have to, because it's even different processes in taxes, W-2s versus I-9s, things of that nature. So I feel we already have a solution. That's the best approach, etc. But can we clarify that verbiage, Leah, just to make sure we're all saying the same thing and that it meets the needs accordingly?
Yeah, no, like you had said, everybody's bringing up a completely valid point. Everybody's point is right, which is why we're having so much discussion over it. And you're right, our inspectors, when they walk in, are oftentimes sort of juggling between, okay, I've got 12 license posted in the hallway. Was that the person I just saw in room 1? And to the credit of everybody on this call, you all run or work for really well-established, well-run businesses. Unfortunately, that's not everybody. We run into a lot of places where we got people pretending to be other people. It would certainly be best for the inspector and the public to say, there you are, there's your license, every station, right? And there's no central location, it's just right next to you with your license. That's obviously the ideal. But then, you know, as Matt brought up, as Lou Suarez brought up, there's things to consider. Are people going to move their license? So I don't have a great solution. I'm just pointing out the different arguments like you had. You know, board staff thinks it's safest for the consumer to have the license posted where you're active and presently working, but you're the professionals in the industry, so you understand the other side of that as well. So if you want to table it, great. If you want to make a motion on it, fine. We can always discuss it at a later meeting. Totally up to you guys. But I don't think we have a great answer. We just got everything you have. We just have options, exactly.
And I think that honestly, I would like to make a motion, but I would like to see a better revision as far as that, if that's the case. And maybe we need to add a line 3 and 4 to clarify school versus a spa, but then we have to clarify measurements and views of, as well as versus hourly rates. And you get what I'm saying? So I think this is going to be within detail, then maybe we can work with some level of verbiage or proposal to clarify that. So if someone goes into someone's spa and they say, no, it has to be where you're working, it would be nice for the owner or the esthetician to say, well, in section 3, we just put it on X, Y, and Z within so many feet of. Right. So if we need to be that clear, I'm fine with that. I'm a-okay with that part. Is that something that the board is open to do, to add sections like section 3 and 4, just to clarify in detail? I would like that clarification because just as Leah said, we do have new inspectors, training is rigorous. We need to make sure everybody's on the same page accordingly, and that's pretty spelled out. School, aesthetics, rooms, things of that nature. And then that way, that kind of eliminates multiple duplicates when it's not needed. You know, I don't want to have to pay 5 licenses for rooms that are literally next to each other. I totally get that concept as well. So is the board open to do that?
Brian Baltazar, that's a great point that someone brought up. As far as specifying distance from the place or the area that the service is being performed, we're really going to have to get specific because it really leaves it open into interpretation. And I think in the entire issue, whenever we've gotten these cases before us, what is plain view? And without really nailing down a specific distance, it's just going to land us in the same quagmire, in my opinion. Now, do we feel comfortable getting that specific? In this case, because it is specific to licensing and being able to identify who the service provider is, as well as for inspection purposes, because again, you know, we've had instances where people are pretending to be someone else or using a license and fleeing a scene, and you know, things that you wouldn't really think happen actually do happen in these cases. It's just in my opinion, by having a central location where all the licenses are at, the individual that is seeking that service is now burdened with, okay, whose license am I looking at? It's like, in my opinion, finding a needle in a haystack. It's going to be a bit harder to identify. And if that's the case, the inspector still has to go and hunt down who is who. And so I don't think that really eliminates the problem for inspectors when they're trying to identify who the service provider is. I think a central location is a great idea, but I still don't think that would necessarily work. That's why I am open to having also duplicate licenses, but that in itself also lends another issue where an individual may be able to get multiple licenses and still act nefariously and have those licenses sold to another individual that may choose to practice under, their identity. So even with multiple or duplicate licenses, if we're going to start getting specific as far as distance wise, I also think that we need to get specific with the number of licenses that are going to be, that we are going to allow for an individual to ask for duplicates. I think it's a fair balance. If we're going to set down limitations, we kind of need to do it across the board.
I agree. I think that and this information is coming from experience in cases and multiples that we've had. This is not coming from a one-sided view of at all. This is coming from looking at everything overall as far as not just schools and certain areas accordingly, but also the different entities of the beauty industry. We have to look at it all together. That encompasses it all. Okay. Euphoria, I see your hands up. Go ahead. I'm sorry.
Well, I just had one more thought while Brian was speaking. We already have in place, I believe, where the person is supposed to register at the board as to where they're working.
Mm-hmm.
So I feel like there's a check and balance there for, because my concern is the same as his, is that, I could potentially, work at 5 different locations and have 5 different licenses, which, maybe I'm not really working at all 5 places. So I think that we already have a check and balance in place. I just think that we need to put it, make it a little bit more active, because I think registering where you work is a good practice to have. And, there could be some sort of documentation, from the owner of the salon that you are working there, and when issuing that duplicate license, so that you don't have somebody just, making duplicates and selling them for people to work under, So I feel like that we already have something in place to counteract that. We just have to, use it is all I think. Thanks.
Thank you, Luz. I'd like to move this to the board to discuss in detail as far as implementing something. I think it'll be a little bit easier in definition and making sure things are done accordingly, because it is the stylist or the nail technician or whoever is responsibility to take care of their space and to keep our public safe. So we need to really take a sobering look at that. And I would like to move it forward to the board to put something down and to make sure that we can have an answer for everyone. I do want the board to please be in mind. I know there's some past board meetings that have been recorded. And it's important, what's going on? And it's important that you kind of know also, or you can ask Leah. Leah is a good person, a point person to go to. How often does this happen? How many cases do we really have? Have people really done X, Y, and Z? Because that's really what we are focused on, is protecting the public. And so we need to know, is this an ongoing real issue? What's really happening here? And so I think that once our lens is a little bit clearer on how deeply a lot of stylists or nail techs are getting away with certain things that are strongly concerning, even aesthetics. Not everyone is using their room for esthetician work. So we need to just make sure that we're in full view of what's really happening outside of what we deal with on the day-to-day basis. There's still some things where I'm just like, I would have never even thought of doing that. So I think that a lot of things have been extremely clear for me, and that's why my point of view on certain laws are the way they are regarding what's been happening too, because we've had a lot of surprising cases dealing with this. Is the board open to moving this to board of Cosmetology, just so that we can kind of get something into place, also have further discussion and start defining some things for laws. If we push this off, it's going to take a little bit longer to get some things done and put in a place for everyone. But if you're open to that, I support whatever you all feel comfortable with as well.
If I could briefly, Matt Brenton, subcommittee member, sometimes there's some utility in having the laws, the language be a little bit vague, because words like plain view of the public and, you know, at the premises, those kinds of things, it does allow for someone to come in and say, well, was it in plain view, and how can we be reasonable there? And if we are having issues with identifying people, if licenses are displayed in one central location, but it's hard to identify, there's other language that can be added, you know, as you mentioned, where we could say something like, if licenses are displayed in a central location in plain view of the public, then the individual practitioners must be readily identifiable, you know, by wearing name tags or something like that. There are other steps to be taken to make sure that those problems we're having, where it is hard to identify individuals, it can be addressed with other good language that would allow the board to see if someone is trying to skirt this, someone is trying to, commit some kind of fraudulent act. There are some other language that could be added without, again, the burden of requiring a patchwork of licenses in every single treatment room, or having somebody haul it around to, 20 different rooms throughout the day. Thank you.
Thank you. I think, thank you, Matt. I appreciate you. And that's the wonderful thing about our staff, is that they're great with law background as well. And they have wonderful things that they can put into place to make sure the interpretation of the law is not muddled or misunderstood in any way. And because we have that strong background, their language is very good at what the Board of Cosmetology votes on and making sure it's clear. And so because I'm very confident in the staff and their background and what they have, we're very diligent in making sure that we have certain people in the proper places to ensure the execution of anything we want to do in law wise. I think that their verbiage on how they develop that will be excellent. I've never had any problems before. And so I think I feel confident in our staff and handling that accordingly. And Gary does an excellent job in navigating things accordingly. So I would like to make a motion to move that forward for the State Board of Cosmetology to go over that verbiage, just as you were saying, Matt, and making sure that things are very clear for everyone. And I think that the staff can handle that accordingly. And the inspections need to be a part of, certain things at all times. So we're just going to clarify that if that's okay with board to move that forward for the verbiage of that, like you were saying, Matt, so that we can have that done. And that's where the clarification will come in at. May I please have a motion to move this to the Nevada State Board of Cosmetology?
Brian Baltazar, I motion to move this item to the full board.
Board Member McCormick, I second that.
Thank you. All oppose? Anyone oppose?
All in favor is your first call.
Oh, all in favor. I'm sorry. I always want to say nay first. I don't know what.
The guy who go over first, I guess, right?
Right. All in favor?
Aye.
Aye.
Aye. Anyone opposed? The ayes have it.
And then just
Thank
for
you.
clarity, because this went on back and forth, we're going to bring this back before the board with this understanding that we're going to add some type of language as per Matt, something that says readily identifiable. So that way we're clarifying slightly, still keeping it vague enough that we can give certain salons certain options, and then we can revisit that before the full board.
Well, I would like for staff to clarify that, because as you know, Leah, with a lot of your information that you have as well, that when words can change a whole meeting. And so we say readily doesn't say plain view. So that means I will show you when I have it. I will, oh, it's over here. So we need to really look at those definitions. Do you get what I'm saying? That's what I'm asking for staff to do. And what we need to do is exactly that, view of the public. And we need to make sure that verbiage is very clear. So when we say readily, we need to make sure that it's not like, you get what I'm saying?
Gotcha. So we'll suss that out a little bit better then before the full board. So I just want to be clear on that's what the motions were, the seconds, and that's fine. I will have that noted and we'll get that on the October or January agenda.
January
Okay.
agenda when we're going to see it again.
Leah, I'm sorry, Madam Chair, I did have my hand raised. Unfortunately, I didn't get to put this comment in before the vote, but I had voted based on pushing it to the board for, and this is Board Member McCormick, being a salon owner, obviously an esthetician, my girls wear scrubs and they also have their names on them. So I do think that the discussion of readily available, especially when we refer back to the conversations on all sides, but in certain proximities and spaces, view of the public is right over there and you are just a room over and you are in multiple places. So I think readily available, but definitely that was my vote to move it to the board to have that language discussed in depth, because I do believe that names being visible is enough too. So I just wanted to add that. So when you are putting it forward to the full board, could you please make sure that we have those options as well?
Noted. Thank you.
Thank you.
Sounds good. Thank you. I'm so sorry. I don't see people's hands being raised. So
that's my fault, Board Member Stan. I'll call it out next time I see it.
Yeah, I don't want anybody thinking like, oh, I'm forgetting you. So okay. Yeah. Let's go to the next one. We're in section 3, NRS 644A.615. Display of licenses, limitation on purposes whom space may be leased, limitations on persons who may be employed. When we open that up and we look at this, any person wishing to operate an establishment for her hair braiding must apply to the board for a license through the owner, manager, or person in charge. Upon forms prepared and unfurnished by the board, each applicant must be contained on a detailed floor plan of the proposed establishment for hair braiding and proof of any particular requirements for a license provided for in this chapter. The applicant must certify that all of the information contained in the application is truthful and accurate. Is there any communication or concern about this?
And just a quick note there, Board Member Stanton, it looks like you skipped over 615 and went to 650, which is fine. We can just do it in that order. But for the
I'll go back just to be safe, because sometimes one protects the other. Let's see. Sorry, I'm utilizing this small device and it seems to. So you're saying I hit 650, not 615.
That's correct.
Okay. So you're saying display of license on a person to whom space may be leased, limitation on a person who may be employed. Every holder of a license issued by a board to operate in cosmetology establishment shall display the license or duplicate of their license in plain view of the members of the general public in the principal office or place of the business of the holder. So basically this breaks down what we were just speaking about prior in definition, correct? Leah, I'm sorry.
This is Gary Landry. This is telling the salon owner when they have to post the salon license, not the individual license. The other section referred to individual licenses. This is for the salon license is what this is talking about.
Okay. Thank you, because I'm like, that's kind of the same thing we just went over. Okay, so is there any concerns regarding that for section 1? Okay, moving on to section 2.
Excuse me, Kai, I'm sorry.
I'm sorry, I can't see everybody. I apologize. I'm not ignoring you, Gwen. I don't want you to think I'm
Okay,
trying
that's
to
why I
be
just
weird.
like, okay.
I'm
okay.
sorry.
Not a problem. So with the salon license, I mean, I think all salons, are we having an issue or with salons not posting their establishment license in the view? And is there any way while we're in law committee that we could put something in place where if the salon has is serving alcohol or have a particular different kind of business license, since the State Board of Cosmetology oversee all, cosmetological establishments, if they are serving or selling something and they need a particular type of license, when our inspection team goes out, do they make sure that that license actually portrays what they actually are serving to clients? I'm going to give it for an example. If a salon is serving liquor to the clients and they have to have a particular city of Las Vegas liquor license, I think you have to have beverage sold license with liquor. I think it has to particularly say liquor. When we're doing our inspections, do we look at that license since we oversee those establishments? I think this is probably a good time to put something in place that all licensing to do with the establishment that we're overseeing needs to be posted in one spot. That's my thoughts.
When this is Gary Landry, we don't look at other licenses like a liquor license, a pot license, a retail license for selling things. We don't look at any of those because that's not our jurisdiction, and that's what we don't get involved in. So I'll be very careful about telling a salon where they have to post someone else's license and whether that has to be posted in plain view, because that's not our concern. That's different laws and all that are applied to them. And we only look for the licenses that we have jurisdiction on, not for other licenses that other departments and other agencies have jurisdiction on.
I will say though that a lot of times if our inspectors do see a good number of alcohol in a salon, they'll photograph it as part of their inspection and it'll be passed to business licensing. So I'm sure a lot of things have been sussed out that way. Some of those people do have a liquor license, some don't, but at that point it goes to business licensing to sort of, discipline.
Because my concern is like moving forward now that marijuana is legal. I mean, we don't have any jurisdiction if they're smoking marijuana in the salons that we license for them to be able to operate that establishment.
Nope, we can't stop them from smoking pot or marijuana or anything like that. We can't stop them from drinking. The only thing we can do, if we find a licensee who's under the influence of pot or alcohol, we can cite and fine them. But anyone else who's doing that, selling it, smoking it, doing whatever, we don't have any laws that say we can do anything for that.
Maybe that's something that we should probably look at in the next legislation. Because I think what I'm seeing a lot of, and I'm just being informed, people are reaching out that in a lot of the different salons and spas that they're serving like liquor, and I've reached out to one of our inspectors, they're serving hard liquor. And I think a concern is when you go into an establishment to receive a service, I mean, how do we monitor who's drinking the liquor and who's not? And we're licensing the establishment. Well, anyway, that's another subject. We'll talk about that offline. But I think that as a salon license, the salon license probably should be posted in the view of the consumers. I didn't know. I mean, I thought that's what is that what we're talking about? The salon license being posted in the view of the consumer?
Yeah, so right now we're just discussing the establishment as far as where it should be displayed, the establishment license. And section 2 is discussing, even though they may have work or is currently licensed in different parts of the industry, you can still, it's just saying you can still open up this space and rent it out to, you know, an esthetician, electrolysis, a nail technologist, things of that nature in section 2. It's just saying these people are not exempt. They're just highlighting that you need to place your license above. It's not connected with any other licenses, etc.
It doesn't sound like that to me.
No, it was just highlighting the display of the licenses for the establishment, because the one prior to was talking about per person. This is like person that's employed. And that's what I was discussing in the last part of it, where I was saying there's so many sections, there's employment, and then there's your own owner. And this section actually defines that. And it's even saying what, to Matt's point and to Lou's point, where they have it all posted in one area. And this is saying, yes, you can do that because you're a school or you're this or you're that. This is going into the details of that. This is what I was asking for prior, but it's already in place.
Okay.
So that's what we were talking about. But as far as the inspector, et cetera, as far as the establishment concerns, we can put that on the meeting on next agenda, talking about the details of the license. So that would go under, like what you were saying, that would have to be a conversation to almost add to the requirements of the license, if you will. That would change requirements to be a license holder, ensuring that moving forward, you need to have X, Y, and Z in place in order to have this into your establishment. It opens up for our inspectors to walk around with a breathalyzer. I don't know how that's going to work out. So I just—
It's not going to work out.
Yeah, no. So I just think that it's going to be a challenge in that direction. So that's something that would have to be on a different agenda. And I would strongly suggest that going to the board versus the subcommittee, because we can only outline and highlight what the board's framework, basically. So if the board says you need to have this in place, this is a challenge, X, Y, and Z, then we can put some other things into place accordingly for that. But that the board would have to vote on that, et cetera. So I would push that to them.
Yeah, not a problem.
Does that sound good? Okay, I'm sorry. The next one, does anybody else have any more statements regarding this law and the establishment? As well as it goes down to section 3, the operator of cosmetology establishment may lease space at the cosmetological establishment to a provider of health care for the purpose of providing health care within the scope of his or her practice. I don't have a problem with that. I think that they're renting a space. The guidelines are there according to what that space is. I would like to see that stay in a place. I don't see why that would propose any challenges unless someone has encountered something that I haven't seen yet, that the verbiage needs to be changed on this.
I have one other question. I'm sorry. This is
No,
Gwen.
you're fine.
So,
I didn't see your hand. I'm not ignoring you.
So
I'm sorry.
That's okay. I just press it. In our law, does it state that as a cosmetological establishment, you can rent space to healthcare providers or any other office space? Because I would like to lease some office space, and I was wondering if we could do that. Is it already in our law, Leah, that we could do that? Like we can have extra classrooms? Because I wasn't sure if we can have extra. You can have extra spaces leased under one establishment license. I wasn't sure of that.
Yeah, we have a number of facilities now. It'll be like a big office building, let's say, and we might license rooms 1 to 3, and rooms 4 and 5 are a chiropractor, and 6
Okay.
and 7 dentist. So we would just ask for an updated floor plan, and we would just license those rooms where our services are provided.
Okay. That's good.
And then section 4 further supports that. Right, Leah, or am I mistaken?
Yeah, so section 4 just defines the terms you read in the above sections. So yeah, healthcare professional, and it defines space.
At this time, is there any other comments between board, any board? At this time, I'd like to make a motion to have NRS 644A.615 stand as is.
Board Member Harris, I would like to have NRS 6444A.615 stand as is.
I have a second.
This is Board Member McCormick. I second that.
All in favor?
Aye.
Any opposed? The ayes have it. Moving on to section 4, NRS 644A.650. If we open that up, that's the one I was reading before, apologize. Any person wishing to operate an establishment for hair braiding must apply to the board for a license through the owner, manager, or person in charge upon forms prepared and finished by the board. Each application must contain a detailed floor plan of the purposed establishment for hair braiding and proof of any particular requirements for a license provided for in this chapter. The applicant must certify that all the information contained in the application is truthful and accurate. Is there any question about section 1 in NRS 644A.650? Perfect. Moving on to section 2, the applicant must submit the application accompanied by the required fees for inspection and licensing. After the applicant has submitted the application, the applicant must contact the board and request a verbal review concerning the application to determine if the establishment for hair braiding complies with the requirements of this chapter and any regulations adopted by the board. Is anyone have any concerns so far in section 2? Okay. Going down to section 3, it's talking about the fees. A 2-year fee is $200, a 4-year fee, 4 years, the fee is $400. And at the very end, the fee for the initial inspection is $15. If an additional inspection is necessary, the fee is $25. I'm okay with those fees. Is anyone would like to have a conversation about those fees during the public? No. And any board members have any questions about this section? I have one question regarding this section. Is a cosmetologist required to be on the premises if it is a braiding license, meaning they have to be on the premises at all times in order for a braiding salon to work? And if not, are they allowed later on to hire on cosmetologists to work in a braiding establishment when they don't have to have one there? So can they rent out a space to a cosmetologist to work in their braiding stations?
Yes, those are both great questions. The first question is, you just have to have someone licensed in the branches of services you're offering at the time. So the short answer to the first question is no, you don't have to have a cosmetologist on staff at a hair braiding establishment. You would just need a hair braider. To your point, of course, if you're going to start doing aesthetic work, nails, whatever, you're going to have to hire out at that point. If down the road a braiding establishment decides they're going to have cosmetologists come on to do more than just braiding, they would submit a new application and request a service change. So what we tell a lot of people to save them time and money is, if you have a cosmetologist on staff to start, license yourself as full service, and that way you never have to resubmit an application with us. And most people, that's exactly what they do.
That's what I wanted to know. How often are they holding truth to just the braiding salon and not branching out without our knowledge?
Yeah,
Okay.
and you know, sometimes we do come across something like that, and the inspectors will say, listen, you have till the end of the week to resubmit with your new floor plan, your new licensees on there. And there's not a whole lot of pushback on that. Most people comply.
Well, I'd like to make a motion. I mean, I would like to have a motion, excuse me.
This is Board Member Harris. I would like to make a motion for NRS 644A.650 stand as is.
May I please have a second? Is there a second for motion to be passed? If there's no second, is there a discussion or concern why there is no second? Did everybody hang up?
Everyone's still here. We're
I'm
taking
not sure.
What just happened?
So I don't know if you were cutting out a little bit. The motion on the table was to allow NRS 644A 650 stand as written. That motion was made by Board Member Harris, and Board Member Stanton has called for a second if there is one.
This is Board Member McCormick. I second that.
There you go.
Thank you. All in favor?
Aye.
Any opposed? Perfect. The ayes have it. We will move forward. Section 5. Section 5 NRS 644.
Board Member Stanton, you're cutting out pretty badly.
Oh, I'm sorry. NRS 644A, 800 advertisements for services relating to the practice of cosmetology. This section, Section 1, the name as it appears on the license and license number for the cosmetological establishment or establishment for hair, braiding, where the services will be provided, and the name, number of the license or certificate of registration of any license or registrant mentioned in the advertisement. Section 2, as advertisement for services related to the practice of cosmetology to be provided at a school of cosmetology, must list the name as it appears on the license and licensing number of the school cosmetology where the services will be held. Is there any revision or a concern about that that should be open for the public at this time? If there's no one that has a concern at this time, is there any board members that have any concern at this time? Perfect. I would like to.
This is Board Member Harris. I would like to motion that NRS 644A-.800 to stand as is.
May I please have a second?
I'll second the motion.
Thank you. All in favor?
Aye.
Aye.
Any opposed? Thank you, the ayes. And moving on our last agenda in section 6, NAC, which is a regulation 644A.870, grounds for disciplinary action. Section 1 engages in unfair or unjust practices, methods, or dealings, including without limitations, copying or altering a license for the purposes of fraud, deception, misrepresentation, or other illegal purposes in violation of NRS 644A.930. Is there any concerns there or revisions for section 1A? Okay, moving on to section B, using a license that has been copied or altered for the purpose of fraud, deception, misrepresentation, or other illegal purposes. Section C, misrepresenting his or her qualifications to the public. Is there any concerns at this time for section B or C of NAC 644A870? No?
Hi, this is Gwen.
Yes. Go ahead,
Okay,
I'm sorry.
so with that regulation, I'm looking at, so are we saying that that's the one that deal with advanced, when you're using the words advanced and expert and all that?
Yeah, that's towards the end. That's in section 2. I think that in section A, they were saying, for example, if I was looking on something on YouTube and then all of a sudden I'm a YouTube expert. So that's kind of what that section A is highlighting, kind of misrepresenting your qualifications as far as I'm a licensee and you've never went to school, you don't hold a cosmetology license, aesthetics, nail technology, etc. So, or selling it. You never went to school, but you purchased a license.
Okay, I'm confused, Kai. I mean, Board Member Stanton. I think that means when it says, and maybe Gary or Leah can clarify it. I think what it's saying is when you're misrepresenting the public, if you're calling yourself an expert stylist and you're using the word expert and we don't have an expert stylist license, I think that's what that means. Am I correct?
That is correct, Gwen. It refers to the fact that if you're misrepresenting yourself using the word expert, advanced, or medical, we'll need to talk about advanced because that's a term that'll be part of the advanced esthetician program. So we have to change that. And we probably have to make one more change in section 2 that'll clarify that other than expert or medical, those are the only 2 restricted terms that we will have. Don't say without limitation. Because we don't want to have it without limitation. That leaves too much to interpretation by the inspectors, by staff. We just want to have it defined words, and those defined words will be the only words that we have restrictions on.
So what we're saying is that we're moving forward using the word, it's okay to use the word advanced because we're going to have an advanced license. But what about the word medical and expert? Because I know a lot of people use, a lot of licensees, because they take the extra training to set themselves in a better position, is like an expert colorist or expert, designer, which in their own terminology, they are experts because they have went over and above what is required as a normal per se license. So what we're saying is that those words expert and medical cannot be used. But if we have it in the law that's saying you can use advanced, what's going to stop a person saying I'm an advanced stylist?
Right. We don't, staff doesn't have a problem with allowing them to use any term. It's just the law as written today. We can't let them use expert, advanced, or medical, and that's without limitation. A lot of other terms can't be used also. So if the purview of the board is to change that, we could eliminate number 2 completely, and that would take care of that. There'd be no limitation on what they can put in front of their license.
I think it should be some kind of limitations, my personal opinion. I think we need to develop as your committee, I would hope that you would develop something that can differentiate what is an expert. Do we have to have extra criteria that is given to the board? Because if that's the case, everybody's going to be saying I'm an expert colorist, and then you do YouTube color, or you know, that I do medical aesthetics, and then if we have it open, then you are going to be doing medical aesthetics, even if you don't have an advanced license. So I think that as a committee, if you guys would take a good look at it before it moves forward, I don't think those terminologies should be used without the certain criteria, period.
Thank you, Gwen. I was, those are very good points, but I was still in section 1. And in those section 1s, I want to make sure that we're highlighting, because I don't want to change section 1. It's important to keep those there as far as selling or offering, sell his or her license. I wanted to see if the public or the board has anything else to add to that. There's a lot of cases that we've come across where that may be before we got into section 2. But
Board member Sandin, you're breaking up.
I'm sorry. Is there, I was looking into section 1 because if there's anything we need to add to section 1 as far as other things that we have come across in the last few things that we've seen in cases, not just selling or offering to sell your licenses, but maybe hours from schools, things of that nature. That's what I was looking for, talking about section 1 to see if we need to add anything into there. I haven't gotten to section 2 yet. We are going to talk about section 2. It is very important to have that revised. There's a couple things. If you don't mind me sharing my screen. Let's see. Can we do it? Can everyone see that? Can everyone see my screen?
Yes.
Okay.
Yes.
So the number one thing I heard was, you know, a lot of advanced training is not supported, and that's zero accurate. There's so much advanced training, as I've heard a comedian say, in the late 1900s and 1998 or what have you. There's a lot of things that have been developed over the years. This is constantly growing, and there are certifications throughout, which is absolutely amazing. That's ongoing. In order to even obtain these things, you have to take minimum of 12 classes, 18 classes, 24. And these aren't just regular processes. I mean, this is a full information on how to not just support your school in other areas, but just as a professional altogether. There are so many other things that are out there. And the reason I chose this to show you is because not only does it hit on what we deal with currently, but it also is a curriculum that we utilize currently, not just in the schools, but personally in our day-to-day to keep our license abreast. So I think it's very important that we are understanding what we're doing and really looking at a lot of things that are out there before we say this isn't accurate and that's not accurate. In section 2, I do see a lot of masters. I see a lot of people that utilize certain names that really clarify how much education that they've had. So I think that it is very important that we remove some of the verbiage out of there. But as far as the grounds for disciplinary action in section 1, I would like for that to stay as well, or add more things to it if possible. Section 2 is the section that I think needs to be altered, that we have some concerns so far. So is section 1, is everyone clear on section 1, or does anyone think that we need to add something else to section 1? Okay, moving on to section 2. I would like to open that up for discussion, is what I just showed you. Uses advertisements for such contain knowing false deception statements, limitation. Yes, false deception statements, including without limitation, using the terms expert, etc. I think we can say that a little bit better, because number one, we don't want to say because you're a cosmetologist or an aesthetics or a nail tech, that you're not smart enough to go advance your education. That's ridiculous. A lot of people have their masters, their degrees, some education, a lot of education isn't even documented how much education people have. So we not like to assume they're not as bright as they appear on paper. You would be extremely surprised. So I think we need to be very, I think we need to change that verbiage on how we can alter that. Now, also masters, doctors, things of that nature. If they come and they have done all of their years college-wise for their doctorates or their masters, that should be considered as well. That is not medical. And that's where I appreciate the highlight of medical, because you can be a doctor of fine arts, you can be a doctor of music. So I think medical is the high word here because there's a medical board and we don't want to step on their toes. So that's where I'm coming from there. They've been very clear about what's okay and what's not okay. And there's a big stern firm about that. As far as expert, I think the term expert, that's fine, but keep in mind, what terms are we utilizing? Because we do not want to disqualify or belittle those that are seeking further education, but not able to say, I have the education for. So yes, I think that verbiage needs to be changed tremendously. There's a lot of things that support the knowledge that are there. And some of those classes, I think one of those bundles are $1,000. And some of those aesthetics classes I've seen for $5,000. So I would like to open it up to the public. And please, I would love your feedback on what's your feedback on utilizing other terms with the exception of medical due to we do have a medical board for that. If you are in NR, et cetera, that's under a whole nother agency, health department, as well as the medical board. So is there any other statements anyone would like for that?
Euphoria has their hand up.
Oh, Euphoria, yes, thank you.
Hi, so in regards to those, master colorists and what have you, I think they're fine, but I think that there needs to be what we really need to look into is a CEUs that would support that. And I think that if we entertain the thought of requiring licensees to obtain a certain number of CEUs, just like an instructor does, I think then that would give the opportunity to be allowed, to use those terms. I've been in this business for over 40 years, and I have seen many people that have put the word master colorist on their cards, and believe me, they're not. And it's not for me to judge, but I just feel like if we're going to grow it, which I am in support of, but I think that for me, the way that would have to be, the way I see it playing out is that it would have to encompass CEUs so that this way it could support when they come to the board to obtain that new criteria or that new title, that they have documentation again that says that they attended and successfully passed those classes. So, that would be my opinion on that. And I think as we go into the advanced aesthetics, I think it's a new opportunity for cosmetology to, maybe have a course as a master colorist in the schools, or, I'm not sure nail techs, I'm not well versed in, but so I think that there's, I think with the advanced aesthetics, it's a great thing. It's an advancement for that particular part of cosmetology. I think it speaks volumes to our industry. And if we raise the bar, I think that it's always better. So for me, I'm in support of those titles as long as CEUs are attached. And that CEUs would need to be approved by the board and validate that, what they're trying to go for, be it master colorist, master cutter, whatever their terminology is. That's my opinion. Thank you.
Hi, it's Gwen. I totally agree. I agree with you, Lou, that it would raise the bar, and there would need to be some type of credentials that submitted to the board, and maybe just noted and documented in the file that this person has X amount, so that when the inspection team sees the information on their sites when they're doing their with the compliance department is doing their compliance, they would be able to look back and say that person does have, and if they're using those terminologies with their advertisement and they don't have it, then it needs to be something in writing stating what we will allow if you want to use that particular terminology with your advertising and with your, I think it's mainly because the board's not going to issue a license stating that, but if they're using that in promoting themselves and the board office have maybe documented proof to show, and the ones that don't, then, then you can go, you do whatever the inspectors do at that time. I agree.
Thank you. I would like to see, to be honest with you, stickers of some sort, not a full different license, but is it possible to have like a master educator's sticker or something just to show that, something that's not crazy that will cause us, havoc in the office, but something we can stick on their license to say they have achieved X, Y, and Z as a cosmetologist. I would like that offered to all instructors. They have to have 30 CEU credits before they even renew anyway. So that's even a requirement period on instructors. So as far as just your day-to-day Cosmo as well, or what have you, yeah, I think that would be extremely important in general. Those details, should the subcommittee be able to do that, or should we push that to the board?
You're cutting out.
Oh, should the subcommittee be talking about the details on this, or just moving forward that we are changing the verbiage and then send it over to the Board of Cosmetology to discuss details and what that looks like?
I would say that, this is Gary Landry again, I would say that the subcommittee would be where you'd work the details out and give those details to the board, because otherwise it'll take a lot of board time to go over creating them. So I would make the creation of the things that you want to do that in the subcommittee, then bring that to the board.
Okay. I would like, oh, yes. Brian, I see you with your hand up. Go right ahead.
Thank you. Thank you, Gary. I was actually hoping that we could possibly go over details in this committee. Sorry, I just lost my train of thought. I will get back to you in just a moment.
I believe Board Member McCormick has her hand up as well.
Yes, go ahead, McCormick. Thank you.
Thank you for, I love the suggestions of being able to to change the verbiage, but I think I'm trying to get a better understanding. So we have just completed, obviously we have a master aesthetics license coming, and the word master is pretty much indicating kind of similar to higher education is kind of what we want to mirror, where you have achieved, certain qualifications. My concern is that the programs, and I know it's based on continuing education, but when we start doing stickers and different verbiage in front of our titles, and it's based on just submitting, something to, supplement based on each individual, I really think we run the risk of having a bunch of people that are actually confusing the public, because I don't understand why it would be outside of school that we would be giving any kind of higher education titles. So could someone expand on that for me?
I'm confused on your question, McCormick.
My question is, why would someone who has not achieved a master's program in a school, an accredited school, get a master's title? If that was the case, then anyone who could find a program online or other that gave them a certificate or something saying that this was a master's program, then we're just moving titles around, is my understanding. Is one of the options is to just submit references to each individual person's training and allow that to be enough for the board to decide. Is that not some of the options that have been placed on in this conversation? So my question is, why would we be giving these higher education titles out just based on individual programs that people are taking? And why would that be outside of school, like the Master Aesthetics program?
So as the advanced aesthetics, that's going to be a different program, which is nice. That's going to go into place. Instructors are required to go to school for their cosmetology license or aesthetics or what have you. Then they have to turn around and go to school again to receive their instructor's license. Then there's another program that they can achieve, and most establishments do offer this program as well. You can either take it by yourself or individually. Not everyone that holds an instructor's license is with a company. Some people have their own private accreditation, so they have their instructor's license as well. So there's other programs that companies do not pay for that would have to be out of pocket, just like with an aesthetics. If I want to take, you know, a special program that's not offered by my school, but I can spend $5,000 and fly to what have you and take this program so that I can work in maybe a certain office or what have you, that is strongly noted. Most people don't take those classes, and that also opens them up to have that stronger portfolio or what have you for that information. It's not very easy just to obtain the advanced aesthetics or the master's. You have to go to school at least twice and then turn around and continue to go to school to even obtain and keep the instructor's license. So that's why that's supported. The other thing is all the information that we get, just like doctors, you know, changes every year. Everything changes and all the information is updated. So it's important that we're a part of that process and keeping things current. And so I liked the idea of, if you are a cosmetologist and you want master in front of, that there is a list that is approved by the board for CEU accreditations to be able to obtain that. It's not easily obtained. You actually have to take these classes. And then that's why we're here. So we can talk about how many classes do you take? What does that look like to obtain that? When you're in the cosmetology field or any other field, you know it's important to have education, current education all the time. And you can show that through a certificate once you complete those classes. The problem is sometimes the license doesn't reflect that. And then not everyone wants to be in the pool of, let's say, someone spending X, Y, and Z on their classes where versus they're not advancing at all. No classes, no nothing. It's almost like it's hard to up your dollar amount also when you say, I can do lashes, but this person can't, but I'm, you know, viewed as X, Y, and Z. So that's why I think that it's going to help a little bit better for us to clarify how many hours. If you are not a licensed instructor, what does that look like? How many hours, et cetera? I think aesthetics is pretty much grounded and detailed. We have a conversation there. As far as the cosmetology or nail technology, we don't. Hair designers, we don't. So that's what the conversation is now, is to say that. The first person I saw with their hand up was Brian, and then I saw Euphoria, and then I saw you, McCormick. Or is that you now?
It is me. And
okay, go ahead. I'm sorry.
Oh,
go
no,
ahead, McCormick.
Okay.
I'm sorry, Brian. I'm not cutting you off, okay?
Oh,
go
no,
ahead,
no,
McCormick.
go ahead.
I'm sorry.
Yeah, no, thank you for you know, just clarifying your points. And I think, to return to my point, I'd like to, you know, just to clarify my previous statement. We're not using master, we're using advanced aesthetics, right? But I think that this board, in making such a strong statement in creating this advanced license, should stick with creating advanced licenses. And I think that it would be just as much of an important conversation to have as to what an master's in what cosmetology, hairdressing, whatever it is that you're proposing would look like, because that is something that can be standardized for all licensees. And that is something that can be achieved by all licensees. And that's what we want to create. We want to create advancement that recognizes, you know, and gives people clear opportunities and a clear outline on how to achieve it. So even though some people may have gone to one training and achieved it, I believe if we're going to offer credentials for our licensees, that it needs to be standardized and it needs to be something that they can accomplish through advanced licensing, not just individual training. So I am
Right.
looking forward to that conversation, but I definitely don't think I would be for allowing too much of a change from what exists
No, and
without
I
like
think
just
you,
cause.
yes, and no, and that's the conversation, exactly what you just said, clarifying. We just don't want people to say, I took my friend's class last week.
Well, to
and
board member Stanton, to clarify, before we talk about hours, that's to me, and it's insinuating that we're going to be changing something. I think that we need, so if we remove the conversation about how many hours before we can say this is so, I think it's important to talk about how do we as a board, given the fact that we have just achieved an advanced license, continue to set that precedence for all, everyone across the board.
Right. And I agree. And you know, the 30-hour CEU credits are a requirement that's been there since the day of the dawn for instructors. And so that was my point. That's already there. Like, you can't even renew your license unless you have those CEU credits, and those are already in place. That's not even negotiable for the instructor's license, and that's just for instructor's license. So my conversation was, there isn't like a bunch of cosmetology instructors license out there, or a lot of instructors license in general out there, but there is a certain level of requirement and a standard. And that could be why too. Not only do you have to go to school, it's twice over on top of your yearly, I'm sorry, your CEUs. I say yearly because it just makes life easier to do it that way. But 30 hours altogether before you even renew. So that's where the hours were coming in at there. The CEUs for, I just say masters because there's no verbiage put into place, definitely, but it is for sure for advanced aesthetics. So that's why I utilize the difference there. But my thing is, altogether, I just want the conversation so that we can put something in place, exactly what you said. I don't want everybody saying, oh, this is what's happening. And so I appreciate that. That's exactly what I'm hoping is a direction that we can have some clarification. Brian, did you have your hand up? I apologize. Go ahead.
Oh, not a problem. Definitely, just to piggyback on some of what board member Luttrell had commented, a clear and concise tiered system. Obviously, we don't want to have two offshoots that really confuse anyone that's seeking these additional titles. But back to my original point that I had forgotten about. As far as issuing stickers or things like that, really, I would be in agreement. My only concern with that would be, how do we catalog that data, and how do we protect the integrity of those stickers or emblems that are going to be given out or what have you from being reproduced? How do we protect ourselves from that? Because if it is just, a sticker with no serial number or no imprint from the board, or something that makes it an official document or what have you from the board itself, how do we protect that system from being reproduced by others that just simply want to circumvent the whole process, or really just want to act nefariously in any way. And the other point is, for data collection purposes, obviously we want to collect all the data as far as, how many licenses or how many addendums. I'm not really sure what nomenclature to use, but how do we collect that data and be able to pass that on and see how successful these additional programs are going to be, or these additional or these additives are. Obviously, we want to be able to collect that data and reflect upon it moving forward and see if that's something that's working for us or something that's not. Because obviously, this sounds like if we were to establish something like this, it's going to exist well beyond any of our terms. We want to be able to set up the future board members that may not be the ones that established this, to be able to look at that data clear and concisely and move forward and decide later down the road if this is a system that they want to continue to utilize. But again, my primary interest is protecting the integrity of any system that we create.
Yes, and that's a very good point. I think in the very beginning, I was just looking at instructors to present to the subcommittee and the board. But then this is a huge cry for the public to push this forward. If you type in master stylist, not only are there salons named that, but a lot of LLCs or entities, and I do mean over 10,000. So if we are going to find 75% of our public, I don't think that's going to be a good turnout for anyone. So I think we need to take a sobering look at that and try to put something in place for what's already currently happening. And the best way to curtail a lot of that is like you said, go ahead and talk about details on what's a good action to take for us to be able to move this forward. As far as the CEU credits, I'm okay with that. I think that's an awesome thing. As far as keeping that, how do we keep the integrity and making sure things are done accordingly? The board can approve the CEU credits that are approved on that list. And if those classes that you've taken are not on that list, then you cannot receive those advancements at that time. And we don't have to utilize a sticker. It can be anything. It could be, maybe a different color license or what have you. That was just a strong suggestion to try to keep things a little bit more easier to process. But I'm open to making sure, my only thing is making sure it is highlighted that there is an advanced education there. I think everybody agrees that needs to be done. Hence, that's why we're doing it for advanced aesthetics. The same thing that we're doing for other entities, instructors, etc. There's already education already out there to support that. So it's really up to us or staff. We can ask staff to research some more programs that further supports that. So if there's any other, I see Euphoria. Go ahead, Euphoria. I'm sorry.
And after Euphoria, I just have a quick comment.
Okay, Euphoria. I'm sorry. Go ahead.
Yeah. So as far as instructors go, I think that's great that we have that title floating around, but not everybody is Milady. There are different. We're Pivot Point. There's Click. I mean, there's a lot of different Lincoln Tech that we have our own system that we go through. So I think that we would really have to bring forth all the different options and really kind of lay out what we expect a master educator to have. I think also it needs to have years attained to it. I don't think it's something that you can just have, when you're out teaching for 2 years. So if we really want to give it, the credit that it deserves, I think that there needs to be a long discussion about what it is, what it looks like, what's required, how many years are required, because there are some things that you can master rather quickly, but then there are some things that you can't. And so I think that, whereas it's a good idea, but I think it needs a little bit more thought behind it, because not everybody is Milady's is all I have to say. Thank you.
Thank you. Now, there's a list of CEU credits, which is a beautiful collection of multiple different schools. So once again, these are just examples. So there's a list that is extensive, which is amazing for CEU credits. It doesn't have to necessarily come through one entity. That was actually shown because there was statements made that there was no support. And as you just said, Lou, there's multiple supports. And so we want to show that and bring that education to the forefront for the public as well as everyone else, so that they see how much education is really out there and supported accordingly. Yes, yes, Gwen, I'm sorry. Oh no, Euphoria, go ahead. I see your hand.
Okay. Right. Well, I agree with you on that, but I think just because there's 15 classes out there and we say you have to take 5 of those classes, I don't think that that's a justification to attach the term master educator onto your license. I think if you're going to have a master's educator license, just like we have an advanced aesthetic license, all right, coming, there's a criteria or a curriculum that's attached to it with specific classes. And I think that it needs to be exactly like that. Otherwise, you know, we have all the, we're authorized to give CEUs, you know, so there's a lot of CEUs available online. But when you talk about becoming a master educator, I think that involves years. I think that it involves attending a school. I think it involves a lot more, because I think when we just say we take 5 classes and now you're a master, I don't agree with that. You know, we went and did a nail tech class. We're not going to say what name it was, but and they enrolled us in a master nail tech class. Now, I've done nails when I was younger, but I hadn't done nails for a long time. And I left there with the title of master nail technician. And it was really a farce, because I was not a master technician. So if we're going to go down that road, I would really like to set aside a time where we sit down and meet and really hammer out what that looks like, what classes you need, what are the years involved, does that include a school? Because I think with the jeopardy that we run here is that our license is always under scrutiny. And I think wanting to elevate it is good, but I think we have to be careful so as to not become, you know, something where anybody can just become a master's and not have any girth behind it, you know. So that's just my opinion. I'm open, but I like the idea, but I think it needs, I think, you know, it took us how long to do the advanced? Over a year. And I think that, you know, if we're going to do a master educator, I think we really need to bring the schools together and really create an outline and put forth what classes they're going to be. And maybe their classes from Milady, their classes from Pivot Point, their classes, maybe they're all different, you know. I don't know what that looks like, but, you know, a list, just like they do when you're, you know, a teacher in a school, there's a list of classes that you have to complete in order to earn that title. So it's not just that we have 100 classes to take from, it's a specific class that, you know, will contribute towards your license becoming a master educator. Thank you.
You're welcome. And I think that's really important, just as we're all, I think, are just trying to meet the needs of our community with ensuring, you know, this is you doing for your students that haven't been licensed yet, and to allow them to have a temporary license. So I do understand where everyone is coming from regarding meeting the needs of all of our students and making sure that the public is being met accordingly, as well as the licensed professionals. So I do believe that this shouldn't.
Can I just say something, Kai, before you wrap it up?
Go ahead, Gwen.
Okay, I just wanted to say I agree that there should be some type of certifications, but I think if you're interested in becoming a master, we're just gonna get on that, because I don't think that's what we were really talking about. I don't know how we got off. I thought we got off on using the terminology as being a master, which I totally agree, because whatever company that you're studying under, if they certify you as a master, you don't need to have it on your license. You should be able to have whatever certification that company has given you. But I thought we were talking about licensees in general, using the terminology expert, using the terminology medical. I thought we only have one license that's coming, and that's the advanced esthetician license. So if you're using the terminology in advertising, I think that's what we're talking about. I think it is talking about using the terminology as an expert in your advertising. So if the board could come up with some kind of information, maybe staff can help develop something stating that if we have these criteria, period, this is X, Y, and Z, you can use it in your advertising. Because issuing a license, that's going to be another 2 years down, a year and a half, 2 years down the road. I think we're talking about using the terminology. Am I wrong or am I right? Because I'm confused now.
No, you're exactly right. In the conversation veered a little bit with me utilizing examples. And so I think I have to simplify things a little bit better. So
Because I
that
can
it
say
was
this,
termed.
okay, can I just say this to you? I'm just saying, I'm not over talking you. I
Oh,
apologize.
you're fine.
I'm just trying to make sure you can end your meeting on time. If you have a master certification from My Lady, Pivot Point, or whatever, your question is, you should be able to advertise that you're a master educator. Is this what I'm hearing?
Yes, that's the conversation.
Okay,
yeah.
so what is going to prohibit you using, if the law, if you guys make a decision to move this forward and you change that, if you have a master certification, you can use that in your advertising if it passes the law, right?
Right, and there's no license needed.
Because I don't think we need to give the board staff any more extra work to do at this point.
I like to make it simple.
Okay, I'm just clarifying.
No, and I'm glad you clarified. We get here. So
it's like, okay, we going way out there.
No, I understand. I was like, what? Okay. So
Okay.
no, that was my, I apologize. That should have been well done. Like I said, I utilized those examples and everyone was responding from there. That's, which is good. I'm glad we have the information out there because there's a lot of things we do need to take a sobering look at. But as far as terms and terminologies, that is direction, absolutely, of what's happening currently. So did that clarify a little bit better, Leah, as far as terms? Because I know you have to rewrite this for the NAC 644A870, the second half, section 2.
Yes, this is Gary Landry. The only term that we're going to be taking out of section 2, from what I understand from all this conversation, is the term advanced, because advanced is now an advanced, we're going to issue an advanced esthetician license. The term expert medical will remain in there. Everything else will remain in there. We just remove the word advanced is what I'm getting.
Okay, so as far as anything else, I would like to see that verbiage supported. If other stylists have taken those classes and they want to utilize those terms, I would love to allow them to do that without having to alter any licenses at that time so that we can focus on what is currently on the table. So can I have a motion to take out advanced for section 2? And also
I think you're cutting out, Board Member Stanton.
okay. And I might need help with this verbiage because I want to make sure that it is said correctly. I would like to have advanced removed. I would like to all applicants of the beauty industry be able to use the advanced training term that they have utilized for CEU. Can we say CEU credits? Does that make sense? I want to make sure I'm saying this right.
We don't have CEUs required for regular licensees, so I wouldn't use CEUs because that's the whole thing you have to.
So what if we take out advanced and expert then?
I thought the discussion was that expert had to be in there, but we can take out whatever this subcommittee wants to do, we can take out. It's going to go to the full board for discussion anyway. So it's whatever you all want to do in the subcommittee is fine. Whatever terms you want to take out is fine.
Okay. Can I have a motion for that, please?
And sorry if this is a subcommittee member, Brenton. One additional option would be if advanced stays in this section of the law. If it's removed, what potentially could happen is, a cosmetologist or a hairstylist, could try and use that term. I understand why we need to remove it because we have the new advanced esthetician license. There is an option to add language that says something like, except, for an advanced, licensed advanced esthetician, blah, 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 right? So it's a carve out for advanced esthetician, and the word advanced stays in, to be kind of guarded, protected for other practice areas. So just one other option. Other than that, if we don't do something that yes, the word needs to be removed. Just that word, I think. I don't know if we've entertained removing expert or medical, just removing advanced. Thanks.
I agree with you, Matt. You must have been reading my mind, because I feel like it should say, you know, advanced except as pertaining to the advanced aesthetic license. I think it needs to be isolated. Otherwise, it's going to be a free-for-all. Thank you.
Brian Baltazar, that makes perfect sense, and I would definitely support something like that.
Board Member McCormick, same.
Can I make a recommendation, since this has to move to the full board anyway? Can staff get some more information regarding using expert in your advertising? Because I think it's just talking about advertising at this time. So it has to move to full board anyway. So is there any way that you can give the board chair, you can give some maybe direction for staff to bring back some more information? Because it sounds like you're just lacking some information.
Yeah, we want to make sure this term is accurate. I know advanced needs to go altogether. There are some other things regarding not just on one group that we need to take a sobering look at, because I just can't turn my back on these people that have really worked hard to get to where they're at, to say that you don't matter. So I think that staff does need to come back with some more information to help with this process accordingly, to make sure that that's done. Because if we're going to speak for 40,000 applicants and 65% utilize certain terms, I would just like to make sure that our verbiage is correct on what's being. Is that okay, Leah?
I'm sorry, I'm here.
That's okay. So my statement is, I would like to have more information regarding verbiage. I know advancement needs to go, so I don't know if we can have a something on the floor, a motion on the floor to take out advanced altogether. I know that has to go, but the conversation is expert, totally get that too, and medical to stay. I'm fine with that. So my concern is, how do we address those that have had extra education, especially instructors, et cetera, and highlight that? Should that be just a separate conversation for later on and move to the board for discussion, or just move the conversation altogether? Or can we separate it and just have the motion now and just take out advanced, because I think we're all in cahoots with that, and then talk about the verbiage moving forward?
Yes, this is Gary Landry. I would say we can bring this section, NAC 644A8.870, to the board with the modifications on advancement. We'll come up with verbiage to show that. Then on the issue of other things like expert, master, medical, whatever, in conjunction with anything else with the licenses, that should be a separate discussion. We ought to have another discussion at the next law subcommittee meeting and talk about what requirements would be there, if any. You know, do you have to show that you took a course? Do you have to show that you passed the test? Whatever those requirements are going to be. And that would give us some time, if we waited to the next law subcommittee meeting, give time for us to review what are other states doing. You know, how many have master, advanced, expert designations in their licenses, and what requirements do they have to get that?
I like that, because there's a few states that actually have that. I've seen that. So that works out. Yep. So I like the division of it. Yep. Sounds good. Can I have a motion to remove advanced?
Is your motion to remove advanced, or to clarify that it's only for aesthetic licenses?
Yeah, that's my preference. Instead of removing it, I think there's some support for some kind of carve out language where we would accept the term, you know, advanced esthetician out, you know, carve that out and let the word advanced stay in to protect it against being used by other practices of cosmetology.
Yes, and we can, if you just direct staff to come up with the language, we'll come up with the language and it'll be at the January board meeting, we'll present it and it'll be shown, shown to the board. This is what staff came up with to be in cahoots or be in conjunction with what the law subcommittee wanted.
Okay, I'm okay with that. I do understand the agreeing on the advancement of the licenses, and that's great. I have no problems with that. I just want to make sure that we are not ignoring the other part of the beauty industry and that we make sure that we're highlighting the education given across the board. So yeah, that sounds good to me. I have no problems with that. I think that the verbiage needs to be clarified as far as advancement for the license, because that has been agreed upon and that is already in motion for the advanced aesthetics. And we should be able to move forward with that and then have a discussion at the next sub-law committee about the details of the remainder. Can I have a motion on the floor for that, please?
Yeah, I'll make the motion. So the motion is to revise, amend NAC 644A 870 to carve out language that will accept out advanced for advanced estheticians, make that an exception to this. The word advanced stays in, otherwise it applies to all of the branches of cosmetology, and the board staff will come up with language for that. And then we table discussion on these kinds of qualifying terms for other branches of cosmetology for a future meeting.
May I please have a second?
Board Member Harris, I second that motion.
All in favor?
Aye.
Aye.
Any opposed? Thank you all. I appreciate your patience and your understanding. I know this was a long conversation, but I think we accomplished a lot, and I look forward to everyone. If you have any questions or any concerns or anything that needs to be added on, please send that over to Leah or to Gary so that we can have detailed information. I appreciate all of you. Without your perspectives and your understanding, it would not be as good and as effective as it is. And so all of you are valuable, and I really appreciate things going well. I mean, we got through this meeting amazing. So thank all of you, and I appreciate the accomplishments. Is there anything, anyone else has anything to say? Any comments from the public? Okay. Well, I would like to say, is there any comments from board members? I'm sorry. Nope.
If I quickly.
I'm sorry, go ahead, Matt. Mhm.
Yeah, Matt Brenton. I just want to thank everybody here on this call, everybody who kind of helped us put some wind in the sails for the advanced esthetician license. We're really excited about it. We're really happy to work with whomever, other schools, other individuals, to help anybody become educated on what the new license will entail, and it's especially schools willing to step into this and start teaching in this area. I think it's going to be an exciting thing for the whole state, for the practice of cosmetology, for consumers, a lot of good things. So I'm excited about it going into effect in January. And I know there were some certain portions of the bill gave license to the board to adopt certain regulations, certain requirements around, specific, instruction. So whenever we want to talk about those at a future date, I'd love to start talking about that as soon as possible.
So what did you want to talk about, Matt?
So for example, section 23 of the new legislation talks about the board adopting regulations to prescribe a curriculum. Mm-hmm. There's other portions of the bill that gives license to the board to adopt regulations. Mm-hmm. And so at some point, those are items that we'll need to discuss.
Well, let's put them on there now. So Leah, on their next subcommittee, Matt, what did you say you wanted on there? Leah, can you hear me?
Yeah, I can hear you, and I follow where Matt is coming from. Actually, we can probably, it makes sense. I don't know if we can do it in subcommittee or it has to be full board. I could be mixing my wires, but I've talked to Justin about this a few times. But either way, the same party, it's an open meeting. And we can start to kind of hash out the things that are going to go along with the law change for master aesthetics, or I'm sorry, advanced aesthetics. because we do have to kind of get the ball rolling. From there, Justin said, once we have our meeting, kind of come up with a framework for things we want to see, we can take every suggestion you have and bring that to LCB, and they can start crafting actual language rather than us, you know, trudging through it. But yeah, let's get that on the calendar at some point. We can do the full board. Of course, subcommittee members are welcome. The public will be invited, and we'll try to make some ground on that so we can get that before the LCB sooner rather than later.
Perfect, Leah, thank you.
So is Matt asking to make sure that we, so I just want to make sure that we're not overlooking him and that we are making sure that everybody is heard, you know, accordingly. So should we have that put on the subcommittee next law, or are you saying that we're not sure yet? Should that go to the board or subcommittee? So we're just going to figure that out and then send out emails? I would like to get the ball rolling, like you said, as soon as possible on this stuff, because there's so much more we need to get through. So I want to make sure that's done accordingly as well and accurately.
Yeah, definitely. I'll give Justin a call. Justin, of course, is our DAG.
Yeah.
How he, you know, wants to handle that. But at the latest, we'll give everybody an update at our October meeting.
Okay. Does that sound good, Matt?
Yep, that's perfect. Thank you.
You're welcome, no problem. Is there anything else that, that was just one of the biggest concerns that you had, you need to push forward on that one? Sounds good. Okay, and I see Euphoria, your hand is up, go right ahead.
Yeah, I'm just a little confused. So has the curriculum been established for the advanced aesthetic?
No, that's not what Matt's saying. What he's saying is we're talking about a couple of law changes and a couple of other things. This was just example of, he hasn't done anything or gone into detail in any way. Nothing has really gone forward of any kind yet. He was just saying that these are the things I would like to take a look at and when is the best possible way to do that. I was just saying, I don't want it to be so delayed. So we were trying to get some information on a meeting so that details can be discussed, but nothing is sketched in stone at all, Luce. That's a very good question. Thank you.
I understand that, but when is that going to happen? Because if the law is going to be effective in January, I feel like, you know, I don't want to find out in December what the curriculum is. I would like to propose, you know, a meeting that happens sooner than later so that we can outline what exactly that looks like, which gives schools like myself the opportunity to, you know, move forward with that.
Yeah, no, let's rest you. No, just rest at ease. That's not going to happen. We are just trying to find a date, and that's why Leah is going to have a conversation and everyone will receive an email accordingly on where that conversation should go. We're not sure if it's subcommittee or board right now. So we're talking to our AG, if you will, and just making sure that the process is accurate. So you will be notified like the rest of us. You're fine. Nothing will go without anyone's knowledge accordingly.
And let me just say, it's a really good point, Lou. It's section 23 of the law. There are kind of broad categories that are that will be required. And if you just look through, it's, you know, it's about one page of information, just general categories like professional ethical standards, theory, performance events, aesthetic procedures, you know, first aid, you know, it talks about physics of wave energy, it just kind of the broad categories. And then the board is authorized to add any additional or clarifying information around that. So there is a pretty good framework for what the curriculum must contain. And I think it just be the board fine tuning it. But I agree, I agree to expedite that discussion as much as possible.
Right, but nothing, I think Lou thinks that something's already in motion and it's not, Matt. That's what I want to clarify. You haven't, you're just asking for that conversation. Nothing has been done. I don't want anybody thinking that you stepped ahead because that's not what happened.
That's not what I was thinking, but.
Oh, okay,
I was just asking the question, you know.
Yeah.
It's going to be coming and there's nothing.
Yeah, so yeah, just rest that ease. But yeah, no, nothing has been done. We're still in process. You're in the same loop as everyone else. Yeah.
Can I just make a comment before you close? I thought that task was given to staff, and staff is developing a curriculum to bring before the full board. Am I correct, Mr. Landry, or no?
Yeah, we are going to create a curriculum, but not, I shouldn't say curriculum. We're going to create any details to the existing curriculum. The existing curriculum is in the law. You want to know what you have to teach, you go in the law. Just like Matt said, here's all the subjects, here's what needs to be taught. That's what needs to be taught. But anything that we need to add to that, saying say anything teaching about lasers, we may add, you need to teach this, this, and this, or these are the only type of equipment that'll be allowed. Whatever those fine details are that the board thinks is necessary to put in, we're going to have that in, but we can't do that until we get from Justin exactly which piece it's going to sit in, whether it be law subcommittee or the board meeting. I think it's going to be a board meeting, quite frankly. It'll probably be the October board meeting if we're going to do something and get that moving.
Well,
forward.
if not, Mr. Landry, can we do right after our AG gets, make that decision? If it's going to go before the full board, can we do an emergency board meeting so that way it gives the schools the opportunity that want to teach the program to start developing their curriculum and all those necessary equipment and curriculum and supplies that they have to have?
Yes, we can do that. It doesn't that wouldn't have to be an emergency board meeting. That could be a meeting among the schools, and the schools could bring that to the board meeting and say, here's what we'd like to see. And they could lay it all out. Because the schools don't need to have, schools aren't on open meeting law controlled. Schools are a private business. You can have any meetings you want. If you want the board members involved, that's when we have to have public meetings, and that's when we have the dates set out by the laws. And that will be a little tight to get something in between now and the October meeting, to have a public meeting.
Okay, but I think some of the concern is because when the schools get together and they bring that information to the board, if the board is not in agreement with what the schools are bringing before, then it's going to drag it out and it's not going to be quite January when they're able to implement it. I think that's some of the concern.
The law states it will be in place in January, and it will. If there's no additional tweaks to it, then it's strictly, as it states, this is the curriculum, this is what you teach. That's the way it'll be done. And there won't be any additions. You can put additions after that, but in January 1st, 2022, is when the advanced esthetician programs are going to be in place and moving forward. Whether the board has taken action or the LCB has taken action or anything else, because the only thing that the law authorized is the board to create additional information, and that's through the regulations, not changing the law, but putting new regulations in. So if there's no new regulations, then you just teach what's there. If you want to modify any of those, that's when you have to get involved with regulations.
Okay, can I just ask one question, and I can probably do this with you later, because I think there needs to be some information circulated to the board members before the October meeting, so that all board members will be able to see what equipment that the state board has allowed for the schools to use, as far as what lasers we're going to be using in our state in such type of equipment. So that needs to be in our law as well. So for me, I would like to have a copy of what the board staff have already developed far as what equipment is going to be used in the schools.
Right, I agree, Gwen, and that's kind of where I'm feeling lost, is there's so many different kinds of lasers with I mean, there's a lot, and I feel a little lost in that, what is the guidelines? What's the strongest you can use? I'm completely lost. And I feel like it really needs to be outlined a little bit more, because it's very vague. And if we want to keep it vague, okay, fine, then we'll just roll with it. But I'm just feeling, I'm like I'm in the dark. That's how I'm feeling.
I think it's a new program, Lou, and we want it to be successful. So we'll make sure that we get something in the law stating X, Y, and Z. It has to be there, or this is gonna be a disaster.
Yeah, I agree.
And we don't want it to be a disaster.
You know, like, you know, there's different things that we use here that can, I don't know, I'm not an esthetician, so I apologize if I quoting the wrong thing, but like you can only use a 3% hydrolonic acid, or, you know, like there's limitations as to what we can use in our scope of practice. And so that's what I'm feeling lost in, is I don't know, when you start to investigate all the different types of lasers that are available, there's a wide range. I mean, there's all kinds of stuff. And so I feel like I feel lost and would like a little bit more of an outline or of somewhat, so that I can better understand what it is that we are allowed to teach.
Thank you, Luz. I see McCormick's hand up, and right before you go, McCormick, I have a question real quick, Gary. I was under the impression all the schools were having a meeting and then everyone was coming up with the information needed, X, Y, and Z, which would also be a part of the information presented to the board. So it sounds like a meeting has not happened yet, and I was not aware of that. Is there a conversation that can be had? Because I do believe every school that is implementing it or not, they need to be a part of that conversation. And I'm just now knowledge that there hasn't been a conversation yet, and the meeting is in October. So I do understand where Luz's concern is a little bit more clearer now. Can you clarify that, Gary? What?
There has not been a meeting yet, but there will be meetings coming up. So that just needs to be scheduled. But the meeting, I was just stating, the meeting of the schools where they're going to put their information together does not need to be a public meeting. It's not controlled by the public meeting laws. That's a private meeting of the private groups of schools getting the information together. And that may not be with information stating, you know, we want to see this taught, this taught, this taught. It may just be a series of questions. We need to know what's the acid content that we can use. We need to know what type of laser equipment we need to have. We need to know, and they can just come up with those things. While they're preparing that, staff will be preparing a list of equipment and of saying, this is the equipment that can be used today. We need to be very careful with putting laser, especially with laser equipment, that we say these are specifically the type of lasers you can use, because as soon as you do that, there'll be a laser that comes out that's able to be used, but it's not on our list, and we have to have an emergency board meeting to get it authorized. So we're gonna have to be very careful about what type of equipment we put. We won't be able to put brands or anything like that. We'll have to say the type of equipment, the type of laser it's going to shoot out, the frequency, the impulse, all these criteria that'll say this is what has to be allowed in our schools, and this is how the students can be taught with it, to make sure we don't get involved in having specific equipment that we have to put in and take out, put in and take out. We'll get into a full-time meeting, a full-time job of just regulating the equipment. So I just want to be very careful on that stuff. It's new to everyone, including staff. We don't have any experience in laser.
That's what I was just thinking, Mr. Landry. I'm sitting here like, what about the inspectors when they go into the schools and the salons to inspect? Are they going to be knowledgeable about the different lasers that the licensees are going to be using? Do they have? Because I know in the medical spas or under the supervision of a doctor, we don't have to worry about regulating those unless there's estheticians in there, right?
Right.
And
sorry, McCormick had a statement as well. When you're done, Gwen, I told her she could go right after me. I apologize.
I just think I'm
just
go
going
ahead.
to
Say this and quit. I think we need to meet with the schools. I think the schools need to have a meeting, and then we can bring whatever back before, because I don't know who's going to be teaching it.
Right. McCormick, did you have a statement? I apologize, and your hand was up.
Oh, no apologies necessary. I actually, between, I think that the executive director and both Matt Brenton and Lou, everyone is definitely just, I think it's clearly outlined. We're just missing that conversation between the schools. And we do have a wonderful resource, being that I think a lot of this can be answered. A lot of the questions of the hows and whats among the schools can be answered. I do do believe that. But also to what the executive director said, my understanding is that we weren't going to start really labeling equipment and, like getting down to really specifically outlining specific equipment, because learning from some of our sister states, such as Arizona, it could be a nightmare to undo that piece by piece. So I think pretty much the conversation just needs to be had. I think that's the only missing part. To your point, Board Member Stanton, I was under the impression that a conversation between the schools was going to be had. So I'm wondering if we can ask for a date, send an email out or a hard date for the response from the schools. And hopefully that will allow them to start scheduling something accordingly.
I agree. And Luz, I apologize. I was under the impression, I don't want anyone under any circumstances to be out of the loop. Everybody's voice is extremely important because everyone comes from different parts of the circle. And so we need to make sure that all that information is there so we don't miss a beat and have to continue to revise. Gary, is there a way we can do a date, or are you saying that is a private thing that the schools have to come together and do? But can they meet at the board off it? Like, what does that look like? Is that what you're saying? That's why we haven't had the date? Gary, I see your hand, McCormick. I don't want you to think I'm ignoring you.
No, it's okay. And while you're on that topic, yeah, I'm saying, even though the board may not govern this meeting because it would be considered a public meeting, not a board meeting, it would be great to send out an email offering the facility and saying we need this information by this date. We're requesting these schools to meet and give us this information by this date. That way it gets the ball rolling, so that they know a conversation needs to be had by said date so that we can meet our deadlines.
And what we were planning on, just so everyone knows, I was going to be sending out an email this week because I wanted to have this meeting to go through and make sure we got everything that was going to be coming out of this meeting. I was planning on having 2 Mondays from now is when I was going to hold the meeting, hold it at the board office, hold it amongst the schools. It doesn't have to be, it's not a public meeting because there's no board members except for Gwen that would be involved in it. And we would hold a meeting to get all the information from the schools that they're looking for and what they think is important to put into the regulations. When we get that, we can then turn that into either a special board meeting just to address this and address the regulations involving the school, the new program, the advanced estheticians program, and get that out. We'll probably have to have a special meeting, not have it a regular board meeting, because it's going to have to be something that we can put together, get all the information and send it to LCB so they can start writing up the regulations. So that was the order of events that we were going to be doing. I want to have it before the October board meeting. So if we had to do anything, we could still include it in the October board meeting, but I want to have that meeting with the schools before the October board meeting.
Yeah, that's perfect. I would like to do it as soon as possible because this
Thank you,
launches,
Director Landry.
whether we're ready or not, is taking off in January, correct?
That is correct. Yeah,
so I just really think that we need to get on top of this as soon as possible. So, okay, sounds good to me. What do we finalize on this before I close out? I just want everyone to be clear. What's our final outcome right now? Is an email is going out? I just want everyone to be clear on what's happening.
Yes, an email is going to go out from me to all the schools, asking them if they can, not asking, we're telling them 2 Mondays from let's see, this 2 Monday, not next Monday, but the following Monday, we're going to have a meeting at the board office for them to come, and we're going to be discussing the advanced esthetician program.
So the 20th of September, Monday.
Correct.
Okay.
Can it be the 27th? I don't mean to be selfish, but
no, it's okay.
I won't be in town on the 20th, and this is really important, and I feel like we could push it to the 27th. It would be greatly appreciated.
That would be fine.
Can I say this, Director Landry? Can you give 2 dates? Because if it's pushed back out to the October 4th, then I won't be in town. So we need to find out from all the other schools. So if you can send that email out and give 2 dates, and then they can all respond to you privately, and then we come up with 1 date.
Okay.
And I have one more question.
Yes, go ahead, Luz.
Regarding the hybrid situation, where are we with that? Where's the board with that?
So right now,
Well, I know
with,
we have it until the governor, declares that it's no longer an emergency, but we were talking about a continuation of that, and I was just wondering, when is that meeting going to be happening?
so as of right now, because that's not on the agenda of the subcommittee, that would go to the board. I'm going to put that in the hands of Gary, and I'm going to ask Gary to email you that information because it is not on our agenda. We really can't discuss it. But what he can do is send you some information, and then we can go into further details on that aspects of it in October on the board meeting. The subcommittee is a little challenging. I'm sorry, Luz. I hope that was helpful.
It just was time for public comment, I thought.
Oh, yes, ma'am. No problem. Gary, can you get her something so she can have dates and clarification on that as well, please, sir?
Yes, I will. I'll send it out to Luke.
Is there any other public comment? Any other board statements from the board?
Well, I'm not on the committee, but I think this was a good meeting today. And good job, board chair, and all those of the other board members and participants. I thought it was a really good meeting. We were able to get, seemed like some clarification on some things that needed to be discussed.
Thank you. And I appreciate, once again, everybody making sure that our public is taken care of and that the schools have what they need to be successful. I'm excited. I think the conversations went very well, and I look forward to seeing you all in the next meeting and seeing this flourish and be successful. So I'm excited for the team that's on board, and sounds like we are about business, getting things done. I appreciate you all. Can I say this meeting's adjourned?
Call for a motion in a second, and call for the meeting to be adjourned.
Okay, I would like a motion to close this meeting for 9/9/2021 at 11:42.
Brian Baltazar, I call to motion to adjourn the meeting.
Can I have a second?
Board Member McCormick, I second that.
All in favor?
Aye.
Aye.
All opposed? Thank you all. Have a wonderful day. I look forward to seeing you.
Thanks, everyone.
Bye-bye.
Thank you.